Poorly written statutes create bad results. This is what happened in the case for Larry and Kay Woodcock in regards to the court ruling. Letisha Stauch is going to wish she had never played games for the last 3 years. The Delphi murder suspect says that he is being mistreated. I asked how long would it take for someone to send love letters to Alex Murdaugh? Not long. Some positive news and information regarding the autopsy of Stephen Smith. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment, and hit that little bell for notifications. And remember, you can listen to us anytime on any of your favorite podcasting apps. Yes, I know I have been gone for a couple of days. Yes, all work-related, trying to resolve some things so that we can spend more time together, ladies and gentlemen. That's right. A lot of homicide cases, trying to wrap some stuff up. It's been crazy. Anyway, let's get to the docket. But before we do, let's support the people that support Crime Talk. Please go to crimetalksearch.com. Sign up for that background subscription service today. We have had more people contact us and say, hey, Scott, thank you. I did a background search on somebody that I was going to get interested in or was interested in, and we're taking it to the next level. And I did a background search and found that they had child abuse or some sort of harm to children charges. Things you need to know. Things that people may not necessarily bring out when they're getting to know you. So go to crimetalksearch.com. When you do, you can do as many background searches as you want. And the beautiful thing is you can cancel at any time. But when you do that search, it is literally prepared while you wait within minutes. And it is emailed to you, and it's going to have information about all of the person's background history, where they're living, their last known addresses. Do they have a criminal history? Do they have liens? Do they have judgments against them? Like I said, things that people don't always come out to tell you when they say, hey, I'm a great person. Trust but verify, ladies and gentlemen. Go to crimetalksearch.com. You'll be happy that you did. Let's go ahead and open the record for April 6th, 2023, and let's get to it. Do you recall the other day when I said that the statute defining who is a victim under the Idaho statutes was poorly written? Well, I do. And guess who agrees with me? Well, Judge Boyce. And it comes up with some not great results, but that's what happens when the legislature writes statutes that don't really think through what's going on. They oftentimes write statutes thinking it's going to be easy. We don't have to think about much. We'll just do it, and we'll let the courts sort it out later. Well, and that's what happened in this particular case. As you may recall, Larry and Kay Woodcock wanted to be classified as victims under the Idaho Victims Bill of Rights. The prosecutor said that they were fine with that. The court really took no position, but the defense raised the objection because they wanted a sequestration order, basically saying that nobody can remain in the courtroom if they are an endorsed witness in the case, and they have to stay out until they've testified and been released. Pretty normal courtroom practice and procedure. But many states, as they did in Idaho, had a Victims' Rights Act that basically said that a victim is able to remain in the proceedings even if they have not testified. So the court issued an order regarding this particular issue, and the court goes through it. And really the argument from the defense was Kay and Larry Woodcock are not really biologically related, so therefore they're not victims. So let me go through the court's analysis. After kind of outlaying the issues like I just did, the court notes that the following facts are relevant to the decision herein. Defendant Vallow Daybell legally adopted victim Joshua Jackson Vallow. Joshua Jackson Vallow's adopted father, Leland Charles Anthony Vallow, Charles Vallow, is deceased. Ethel K. Vallow Woodcock, Kay Woodcock, is the biological sister of Charles Vallow, the adopted father to the victim Joshua Jackson Vallow. Defendant Vallow Daybell is the biological mother to the victim Tylee Ryan. Summer Shiflett is the biological sister to the defendant Vallow Daybell. Now, Colby Ryan is the biological half-brother to Tylee Ryan and the adoptive half-brother to Joshua Jackson Vallow. Defendant Vallow Daybell has no relationship to the victim, Tamara Daybell. The court then goes on and explains Rule 615, which is the sequestration rule that basically says, at a party's request, the court may order witnesses excluded so that they cannot hear other witnesses' testimony, or the court may do so on its own. But this rule does not authorize excluding. And then paragraph 4 says, a crime victim whose exclusion is prohibited under Article 1, Section 22 of the Idaho Constitution, which is their Victims' Rights Bill of Rights. So then you have to go there. Does this sound familiar? Didn't I go through this just the other day? Yes, because we broke it down like a lawyer would. And Article 1, Section 22 of the Idaho Constitution states, rights of the victims. A crime victim, as defined by statute, has the following rights: to be treated with fairness, dignity, and privacy throughout the proceedings, to be present at all criminal justice proceedings. And then it further states in Article 1, Section 22 of the Idaho Constitution that Idaho Code Section 19-5306 enumerates the rights afforded victims of crime. Under the statute, victims means an individual who suffers direct or threatened physical, financial, or emotional harm as a result of the commission of the crime. The Idaho section clarifies the provision of this section applies equally to the immediate families of the homicide victims. The court may designate a representative from the immediate family to exercise these rights on behalf of a deceased, incapacitated, or minor victim. The Supreme Court of Idaho has clarified who qualifies as immediate family. In a case called Shackelford, the court considered who was the immediate family member for the purposes of receiving victim impact statements in preparation for sentencing. And that case held that the court finds that immediate family members as parents, mother-in-law, father-in-law, husband, wife, sister, brother-in-law, sister-in-law, daughter-in-law, or son or daughter. Yep, exactly. As a threshold issue, the court notes that there is a procedure within the statute to aid the court in being notified of who the state contends is a victim. To date, and after an express request, the clerk of the court has still not received this form in this case, required by Idaho Section 19-5306, that indicates to the court an individual asserting their rights as a crime victim, thus invoking the rights afforded under the crimes victims under the Idaho law as set forth in the statute. So, what does that mean? It means the prosecution never bothered to follow the statute to say who they designate basically as family members. It then states the court must determine who is the victim under Idaho law in order to ensure compliance with the exclusionary rule. To be clear, family members of crime victims are always permitted to attend criminal proceedings, including the trial in this case. The exclusionary rule is limited to prohibiting a testifying witness from hearing another witness testify, and thus the exclusion only occurs when testimony is elicited at trial. The court is in no way minimizing the significant impact of losing family members to homicide, no matter the nature or closeness of any kinship. Further, the court has never attempted to preclude any family members of the victims, J.J. Vallow, Tylee Ryan, and Tamara Daybell, from attending criminal proceedings, as evidenced by their frequent appearances in court during their pretrial litigation in this case. However, previous attendance does not justify future inclusion for the purpose of determining whether or not a person meets the legal definition of victim in Idaho. That is strictly a legal determination the court must make. Simply put, only legally qualified victims may observe trial testimony before offering their own testimony. If a witness is not legally qualified victim, their testimony will likely be prohibited if they first observe other testimony, which is the rule under the exclusionary rule. Thus, it is incumbent upon the court to ascertain who meets the legal definition of victim, and immediate families of homicide victims in Idaho fall within the purview of the exception from this rule. The state has argued that Kay Woodcock, Larry Woodcock, Colby Ryan, and Summer Shiflett are all qualified victims for the purpose of accepting them from the exclusionary rule. The defense disagrees, arguing the state is mistaken in assigning status as victim to these individuals. Certainly, the court does not question the emotional impact of the alleged victim on any of these people the state puts forth as victims. Neither is the court insensitive to the hardship presented to any of them. However, the court is constrained by law. For purposes of applying an exception to the exclusionary rule, Under Idaho Rules of Evidence 615, the court cannot find that Kay Woodcock initially qualifies as a victim. However, because a homicide victim cannot assert their rights for the victim, the Idaho legislature codified 1953-06, paragraph 3, to extend the rights to victims to their immediate families of homicide victims. In Idaho, Kay Woodcock does not meet the legal definition of immediate family member of any of the victims, but Charles Vallow does. As a parent of Joshua Jackson Vallow, Charles Vallow is an immediate family member who is afforded the same rights conferred upon crime victims. The record reflects that Charles Vallow is deceased. Kay Woodcock is the biological sister of Charles Vallow. Accordingly, the court has authority to designate a representative from the immediate family to exercise these rights on behalf of a deceased, incapacitated, or minor victim when a member of the immediate family is unable to fulfill the role. In the interest of justice, the court finds it is wholly appropriate to designate Kay Woodcock, the representative for victim Joshua Jackson Vallow, in Charles Vallow's stead. As such, she qualifies to be accepted from the exclusionary rule for testifying witnesses under Rule 615 and may observe the trial testimony prior to any testimony she may offer. The court then goes on to discuss Summer Shiflett, saying that she does not meet the legal definition of immediate family member of any of the victims, but the court clarifies that Ms. Shiflett is the biological sister of victim Tylee Ryan's parents, where Tylee's mother is defendant J.J. Vallow and where her father is deceased. Neither of Tylee Ryan's parents are available to fulfill the role of immediate member. Thus, the court determines that Summer Shiflett is appropriately designated as the representative of the immediate family of Tylee Ryan in accordance with Section 19-53063, and Summer Shiflett therefore qualifies to be accepted from the exclusionary rule. Colby Ryan meets the definition of immediate family member because he is the brother of Tylee Ryan and Joshua Jason Vallow. Accordingly, he qualifies to be accepted. Finally, before the court is the issue of Larry Woodcock. Larry Woodcock does not meet the legal definition of immediate family member in relation to any of the victims listed by the state. The state has included Larry Woodcock on the list of witnesses expected to testify. As such, he is subject to the exclusionary rule under 615. This means that Larry Woodcock is precluded from observing trial testimony prior to the testimony he offers at trial. He may, however, observe all proceedings where testimony is not being offered, and upon the completion of his testimony, he would be permitted to observe the remainder of the trial. The state has the means in order its testifying witnesses however it sees fit. Should the state wish to call Larry Woodcock early in the case, in their case in chief, that is entirely them. And this is where I get how the court did it. I was concerned based upon the language from the statute that the Woodcocks were going to be excluded in their entirety, but the judge did designate Kay as a family representative. But the court notes, in sum, the court is disappointed by the statutory form required under Idaho Code Section 19-5306, subparagraph 2, and has not been provided to the clerk of the court in order to clearly identify and protect the rights of crime victims, their families, immediate families, and illuminates a need to designate representatives from the immediate family of the victim in this case, which may have prevented much of the confusion surrounding this issue. The court still requests that the state confirm who is meeting their status of the victim to comply and to keep the record clear on the issue. Nevertheless, court is in its decision will appoint Kay Woodcock as a representative for Joshua Jackson Vallow and will appoint Summer Shiflett as a representative for Tylee Ryan. Colby Ryan meets the definition of immediate family and for both Joshua Jackson Vallow and Tylee Ryan. So the court kind of came to the same legal analysis and conclusion that I would have, and I think I even noted that I hope the court would tailor something so that it would be fair. He kind of split the baby on the Woodcocks, but at least Kay will be able to be there for the entirety. And I'm assuming the government is going to put on Larry Woodcock's testimony somewhat early on, so hopefully he'll be able to observe most of the trial. Now, the Woodcocks did file some motions based upon attorney that they had retained, and the court denied the Woodcocks attorney's motion, basically saying they had no standing to participate in these proceedings since it is a criminal case in the state of Idaho. Although you would think that they would have standing as a victim representative now, but I get it. The court has ruled, sometimes courts don't get to make the decisions they want. They have to follow the law. So there you go. Now, jury selection continues. They're close, and it is anticipated that opening statements for the case of the people of the state of Idaho versus Lori Vallow will start next week. The court and the attorneys are trying to pick, obviously, 12 jurors who will be picked along with 6 alternates. And like I said, Judge Boyce has said that they anticipate doing opening statements Monday at 8:30. Now, of course, remember, it's too sensitive. You can't watch the proceedings. It's just not fair, which I think is a bunch of hogwash. I disagree with Judge Boyce's legal reasoning. I think the state of Idaho needs to have the legislature, if they're going to do something, err on the side of complete transparency in the court system so people know what is taking place, and that people can see the trial, or at least provide a means to appeal the court's order. Because what if the judge is acting arbitrary and capriciously and just does what he wants to do? I mean, this is a case of international attention. What would be the better showcase for the courts to showcase that it is a fair proceeding, that it's not some sort of show trial that we see take place in some communist country? God, I hope that's not going to take place here, but a little scary. Why would the government not want the cameras there? I don't know. It just drives me nuts. I don't know. Maybe if the prosecutors in the Lori Vallow case spent a little less time worried about whether the cameras are going to be in the courtroom, they could have spent more time filling out the appropriate paperwork with the court as defining who's a victim under the Victims' Rights Act. Just saying. All right, next on the docket. It may not be great quality, but guess what? We're bringing you the Letisha Stauch trial. For those of you not familiar with it, Letisha Stauch is on trial for the death of Gannon Stauch, her son, adopted son, stepson, I should say, to be more accurate. And this happened literally 3 years ago. Well, testimony is coming out, and it is not good for Letisha Stauch. Now, early on in this case, we read the affidavit for the arrest warrant, and I said she has got a bunch of problems because she gave at least, 12 different versions of what took place. Yeah, all that's coming back to haunt her. And when you have your faculties about you to come up with so many lies, it's really tough to say that you were having this out-of-body experience, and which is the reason why you shot, stabbed, beat young Gannon, drove his body across town, hit it, picked it back up again, then drove it across the state, dumping it under a bridge in Florida. It's going to be a tough road for Letisha Stauch. Anyway, we heard testimony of her denying that she was the killer of her stepson and then blaming his disappearance on an attack by a man named Quincy Brown. Letisha Stauch also told Gannon's dad that the boy was injured in an accident and then taken by a man she was meeting up with through Craigslist to buy an exercise bike in Douglas County. He promised he was going to go back to his house and get some bandages and call 911, and then Letisha went on saying that he never came back. And obviously never came back with Gannon, did he? And she just didn't know what to do. None of it was true, according to the prosecutors. Now, like I said, Gannon's remains were placed in a suitcase from the Stauch home and then dumped under a bridge in Florida, where they were found in March of 2020, weeks after, obviously, Gannon had gone missing. Now, through this process, a trial, we've been able to see that Al Stauch began working with investigators after he realized that Letisha, well, let's say she was holding back some information. And prosecutors have played hours of recordings between the two, during which Letisha Stauch told various stories about what happened to Gannon. In one exchange, Mr. Stauch poignantly asks his wife whether she killed Gannon. In fact, he said, "Did you kill Gannon?" Letisha responded, "No." "Did Gannon die on your watch, whether it was naturally or through some injury?" "No." "Did you have an accident of some nature and you freaked out and you just had to cover it up?" Letisha responded, "No." She told him that a man had broken into their home, raped her, and attacked her, and then took Gannon. He said he asked why there were no signs of a struggle in the home, and she replied, "I cleaned it up. I got scared." In other calls, she named her alleged attacker as a man by the name of Quincy Brown and said that investigators were barking up the wrong tree by focusing on her and not the man. She also said that Gannon had been picking at his fingernails quite badly and that they began bleeding, which obviously clearly explains how the blood got on the wall in his room. Now, at a previous hearing, the officers testified about blood found in his room and the other areas below the room. The laundry room, the family room, Gannon's bedroom, garage, storage room, stairs. Yeah, Letisha Stauch gave explanations for some of that blood during her calls to her then husband. One time she said that Gannon had gone out barefoot, taken out the garbage, stepped on a nail in the garage and cut his foot, which resulted in him bleeding on the board. She had an answer for everything. Thou protest too much, I think Shakespeare once said. Then the jury also heard from Macon Ponder. He's a dive leader and was doing a bridge inspection for the Florida Department of Transportation. And he testified that, like I said, he was part of this crew inspecting the bridge, and they came across this suitcase back on March 17th of 2020. The inspector said that he took note of the suitcase, then later returned to open it, but it had a, quote, smell of death. He said it was not unusual for his dive team to find deceased puppies and other animals tossed under the bridge, but the smell was particularly bad in this particular case. He then noticed what appeared to be a body and two little feet that had football socks on them. Needless to say, he immediately contacted the police. Then an investigator from the Santa Rosa, Florida Major Crimes Division, Detective Jason Yoder, also took the stand and detailed what he found in the suitcase upon arriving at the scene. He said that there was a suitcase on the ground open and what appeared to be a human body rolled out of the suitcase, covered with bedding and a pillow. He added that the body was dressed in jogging pants and an athletic top and football socks. Now, Yoder said that they determined the body may have been Gannon by noticing his distinguished front teeth, while the body size and description matched a flyer from the El Paso County Sheriff's Department. Yeah, now Letisha Stauch is, trying to hold her head down, trying to make herself very small in the courtroom. And I'm sure if we could see the jurors, they would be burning holes in her with their eyes. Welcome to trial, Letisha. You wanted to play games? Welcome to trial. Now, she's pled not guilty by reason of insanity, which means she did it, but that she was not capable of prizing right from wrong at that particular moment. We'll see how that particular theory holds up throughout trial. Now, if you listen to the opening statements by the defense, it was pretty much a mea culpa of, hey, don't hate us. This is my job. I have to do this. And, the reason why it makes no sense, why she would kill young Gannon, because there's no motive. Why would she do it? So therefore, she must be crazy. I just summed up their closing argument, and, well, that's their case. We'll see if a jury buys it in several weeks. Next on the docket, the Delphi murder suspect says that he is not being treated very well. That's right. Attorneys representing Richard Allen, he is the alleged Delphi suspect. They're requesting that their client be moved to a new holding facility, saying that he is in this high-condition security system, which is akin to those of prisoners of war. And in order to frustrate his ability to defend himself is why they put him there pending his upcoming trial. As you may recall, the judge moved him from the small county jail for his own protection. Sometimes be careful what you wish for, right? Anyway, Mr. Allen's attorneys filed this emergency motion to modify the safekeeping order, and the attorneys have basically said, hey, Judge Fran Gull, please order that Mr. Allen be removed from the Westville Correctional Facility, where he's been housed since November of 2022. The attorneys make a list of grievances alleged in their motion, and that includes that Mr. Allen is forced to sleep on a pad on a concrete floor. He only showers twice per week, has been prohibited from seeing his wife and family, and is permitted very little recreational time. They say that he has been entombed in a cell as small as 6 feet by 10 feet in length and no larger than that of a dog kennel. In some, Mr. Allen is being treated far less favorably than a convicted person, many of which are housed in less secure areas of the prison, are afforded programming, therapy, and mental health services, routine recreational services, and contact visits with their family. Mr. Allen has been segregated inside the maximum security prison with individuals who have committed some of the most heinous crimes known to our society, and the austere conditions have had severe detrimental effects on his physical and mental well-being. Well, you know what may not be to his best physical and mental health well-being is going to general population. Now, I understand he's being held at a prison even though he has not been convicted of a crime, but that's apparently for his safety. Why would a court think that a guy in a high-profile murder case allegedly killing 2 young teenagers would be at risk in general population? Oh, that's right. He's a high-profile defendant accused of killing 2 young teenagers, right? There is a hierarchy in prison. If you harm a child, you are on the bottom of the barrel, okay? Whether it is doing something of an inappropriate nature or let alone killing a child. You have to remember, most of the people in prison had a pretty crappy childhood. And so they don't take kindly to people that make other people's childhoods crappy as well. So it may not exactly be staying at the Four Seasons or the Ritz, but the state has a duty to make sure that he gets to trial. And it's unfortunate, but he could always post a very high bond if the court were to set one. Just saying. Or he could have exercised his right to go to preliminary hearing early on to see if there was enough evidence in the case. None of that's taken place because he has continued the matter. Just saying. You can't have your cake and eat it too. Next on the docket, Mr. Alex Murdaugh. Do you remember early on when he talked about Alex Murdaugh when he's being sentenced? I wonder how long it would be till he started getting those love letters in jail saying that I love you. They have started, ladies and gentlemen. Apparently, Mr. Alex Murdaugh will be bombarded with well-wishers and future love interests. I've told you this before, and I'll say it again. I do not get it. I know there's lots of studies why women, men, would want to date somebody who's never getting out of prison, someone that you'll never be able to consummate your marriage to if you decide to get married to. I don't get it. They're done. They're gone. Bye-bye. Just saying. Doesn't make any sense to me. Do what you want. It just doesn't make sense. Next, Stephen Smith. Remember, he was the 19-year-old that was found dead on Sandy Run Road in South Carolina in Hampton County, and after an autopsy of his death was ruled a hit and run 8 years ago, although there's been, well, let's just say some criticism and some skepticism from law enforcement, including Smith's mother, about that initial ruling. Well, the South Carolina Law Enforcement Division, known as SLED, said that the Smith's family attorney, Eric Bland, that an unidentified evidence related to Smith's death was uncovered during the state investigation into the Murdaugh murders. And after a considerable amount of time, it's often difficult to retain substantial new evidence. However, this did not seem to be the case with Smith's case and his autopsy. As you can recall, he was exhumed last week, so they conduct an autopsy. And they expected that the final report will tell us a little bit more about how he may have died. The authorities said, I do know it was a success. They said they did collect evidence. It was very good documentation, and everybody was upbeat about the information that, in fact, was collected. The authorities stated that this is not always the situation when you exhume somebody after so many years after being placed in a grave. Investigators were excited about the new report coming when asked whether anything significant could be learned from the body that was exhumed. Well, I don't want to take it the wrong way, but they are very excited about the forthcoming report. Pathologist was apparently upbeat and said that they had everything they needed to properly examine Mr. Smith, and they didn't hear anything negative about that, and they were saying it was a very good situation for the Smith family and the investigation, and that all had their fingers crossed, looking forward to getting some resolution for the Smith family. An attorney for the Smith family announced the body being exhumed and the autopsy taking place on Sunday. We'll have to wait and see. You just never know how these things turn out.
As a pet owner, you want to give your furry friend the very best. That's why Baked in Colorado's CBD-infused dog treats are the perfect choice. These delicious treats not only taste great, but they also provide a wide range of health benefits for your pet. CBD has been shown to have many positive effects on dogs, including reducing anxiety, alleviating pain and inflammation, and improving overall wellness. Baked in Colorado's treats are infused with premium, full-spectrum CBD oil, meaning your pet will benefit from the whole plant extract. Not only that, but Baked in Colorado's treats are made with all-natural human-grade ingredients, so you can feel good about what you're giving your pet. They're also free from wheat, corn, and soy, making them a great option for dogs with food sensitivities. Baked in Colorado CBD-infused dog treats are the perfect way to support your pet's health and well-being. With various flavors, including peanut butter, pumpkin, and bacon, your dog will love them too. So why wait? Head to www.bakedincolorado.com today and order your dog a bag of these delicious and nutritious treats. Your pet will thank you for it.
All right, and then finally today, our dumb criminal of the day. Please meet Mr. Justin Miranda. He was spotted Sunday evening operating a motor vehicle that had fake New Jersey license plates. And when a Clearwater Police Department officer approached Mr. Miranda on foot at a red light, the Newark resident took off and at that time restarted the bike. Mr. Miranda then allegedly ignored the stop police orders and sped through a red light, putting the surrounding driver in danger. Moments after fleeing the police, Miranda was involved in a motorcycle crash, after which he was transported for treatment to a local hospital. After being read his Miranda rights, Mr. Miranda, who works in car sales, opted to remain silent. Good call. Mr. Miranda was charged with felony fleeing, a high-speed wanton disregard when trying to elude from the police. Jail records also indicate that Mr. Miranda, who is being held in the county lockup, is a fugitive in connection with a parole violation in another state. Do you think that could have been any reason why he may have fled? And did I forget to mention, ladies and gentlemen, what Mr. Miranda's license plate said? Yeah, the fictitious plate. Bend over. There you go. You can't make this stuff up, ladies and gentlemen. All right. Sorry, I was out for a couple of days. This lawyer stuff is getting old. Anyway, thanks for watching. We'll see you next time on Crime Talk.